So, welcome Dan Leftwich.
So, thank you to everyone for coming, and to the folks at Yes on 301 and Broomfield Concern and Logic and all the great grassroots citizens groups that have formed. They're all trying to work together and become experts. That's what we have to do in this environment. Now, everything I'm going to tell you today, from a legal standpoint, I'm going to try and make it, accessible. And everything that I'm going to tell you is supported by decisions of the Colorado Supreme Court, the United States Supreme Court, or the Colorado Court of Appeals in the case of the Martinez opinion that was just referenced. Now, this was named the real deal on 301 because there's a lot going on that you may or may not know about, but you've heard about. You've heard snippets here and there. You've heard references to preemption and how 301 is going to be invalidated by the courts, and the Longmont decision, the Martinez case. I'm going to try and explain all that to you. And in the meantime, I'm going to reveal some myths and magic tricks. So, wait for that. Now, this is where we are, and I always like to open up with a broader perspective. I know that everyone here in this room is concerned about right here, and health and safety, protecting the environment, but this is where we are. We're at extreme energy, okay? They're not going to the ends of the earth and fracking and tar sands and Arctic oil for nothing because they can, okay? Because that's where it is. It's the race for what's left, all right? So we're at extreme energy. That is extremely degrading to our environment. And it leads to a stagnant economy. Now, this is where we want to be. Okay? I try to get people to have a vision for where you want to be. All right? Yes, fracking, it needs to be reined in. It needs to be stopped in places. All right? But we have to have a bigger vision because events are taking over. All right? So we want to be in a place where renewable energy is the norm. We want a restored environment, okay? A healthy environment. And we want resilient communities. And what do I mean by that? Well, there's all kinds of shocks that are already here, okay? I call them black swan events. They're arriving daily now, okay? Megastorms, droughts, fires, okay? Every day you open up your inbox and there's news of some totally unprecedented and what used to be unexpected events. This is nature's way of saying, can you hear me now? Okay? So we want resilient communities that can withstand these shocks and move to the broader vision, okay? Restored environment and renewable energy. But to do that, we've got to get through these shocks, okay? Now, what's stopping us, right? Local self-government is under assault through preemption. Now, I'm going to explain to you what preemption is. Some of you may already know, and that's fine. It's by corporations aligned with ALEC, the American Legislative Exchange Council. This is the Koch brothers and other really right-wing groups, okay? They're using the power of money, and it's really just the power of money, all right, to subvert local democracy. They've already subverted state democracy. Now they're after local democracy. So what is preemption? Preemption is the power of a superior level of government to control how laws are enforced at lower levels of government. Now, just a little bit of background. Where does preemption come from? Well, it really comes from federal preemption over state laws and local laws that are in conflict with federal laws is based in the supremacy clause of the U.S. Constitution. Okay? It says federal law is the supreme law of the land. So any state laws that are in conflict with federal law controls. Okay? But that's not what we're dealing with here. We're dealing with state preemption over local laws. All right? That's a fiction. Okay? It's a judge-made, it's a court-made fiction. All right? It's based on something called Dillon's rule. See that up there? And this is a little history lesson for you. Back in the 1860s or 70s, a judge in Iowa, the Chief Justice of the Iowa Supreme Court, a corporate lawyer, ruled in a case that because municipal corporations, cities are municipal corporations, they're created by the state, the state breathes life into the corporation, gives it its powers, and it can take them away. That's the basis for preemption of the state over your city. Okay? But keep in mind, there's a difference between the municipal corporation that is a city and you. Okay? Now, this is the correct hierarchy. The people are at the top of the pyramid. Okay? Then there's federal law, state law. Home rule cities are more powerful than just statutory cities. But the state says our rights are down here. Okay? I'm going to tell you otherwise. So what does preemption have to do with 301? Well, 301 is an opportunity to assert your fundamental right to legislate, to protect your own health, safety, and the environment. In the fracking industry, it's the oil and gas industry, but it's really the fracking industry. They're using all their power, all their money in state government to use state preemption power. It's not their power, it's the power of the state. Okay? To preempt local governments, local communities from passing their own measures to protect their own health and safety. That's what happened in Longmont, Fort Collins, and Lafayette, and Broomfield in 2013. Okay? So why do we need the right of initiative? Well, I'm going to take you back to 1910. All right? Imagine what Colorado was like in 1910. The Supreme Court says the powers of initiative and referendum initially developed out of fear that state governments would be controlled by special interest groups. Does that sound familiar to you? Really? Okay. In 1910, the right of initiative was reserved. Colorado, one commenter commented, it was stewing in a vat of malodorous municipal and corporate corruption. That's pretty colorful. Now I read another commentary that said, the state government was full of boodlers, bribe takers, and petty politicians. Now, I don't know what a boodler is, but it's probably not very good. So, maybe you think, well, but that was 1910. Surely we've evolved since then. Well, yeah, we have, but today's version is just more sophisticated, okay? It's still all about the power of money, and now it's been unleashed, okay? Citizens United, the case of the United States Supreme Court that says corporations can give unlimited amounts of money in order to basically influence elections, all right? And so basically, I urge you to go to the Boulder Weekly and see this article from last year, Behind Closed Doors. It lays out a shocking expose of the oil and gas industry's collusion with the COGCC and politicians, okay, to control city councils, prevent any initiatives, and basically lock up, through preemption, the power, all right? The power to stop you from protecting yourselves. It was on tape, okay? So you can read the transcripts, right? And Boulder Weekly connects all the dots. Who was there? What are they talking about? Who was giving money to who? How much money? It will shock the conscience. So here's what the Colorado Supreme Court says about the real balance of power in this state. The balance between the legislative power of the General Assembly and the legislative power of the people, you, has been struck in favor of the people in the fundamental charter of our state, the Constitution. No statute, this is the important part, no statute passed by the General Assembly can be permitted to alter this allocation of power. Think about that for a second, okay? Preemption is based on the Oil and Gas Conservation Commission using the Oil and Gas Conservation Act, okay? Its statute, the statute that the legislature passed, giving it its powers, it uses that statute to say, well, we're the ones who get to regulate oil and gas, and you local communities, you don't have that power, okay? Well, in this state, the power of initiative, the right of initiative, your power to pass direct legislation is superior to the power of the legislature in Denver. Why is that? Well, because we created the legislature, okay? Unlike Dillon's rule, which is the legislature created the municipal corporations, gave them their powers, and can take them away, you gave the legislature its power. You created it, you can take its power away. And you can do that in a variety of means, okay? You can pass legislation that says, in or for your community, and I'm going to get to the actual language of the Constitution, that says, no, we don't want, we think fracking is inconsistent with residential areas. Therefore, setbacks need to be, 2,000 feet, 2,500 feet, okay? You could do that. I'm telling you, you can do that, all right? And I'm going to show you why. You have plenary authority. Now, there's been a lot of commentary about the section on 301 that says, well, we're giving the city council plenary authority to regulate in support of your own public health and safety. Well, that's a novel concept. One of the unquestioned purposes of the referendum and initiative powers is to permit the total and free exercise of legislative power by the people. The power to call referendum and initiative elections is a direct check on the exercise or non-exercise of legislative power by elected officials. So if your city council isn't doing what you think they ought to do, you can pass an initiative that says, you're going to do this, okay? This is the law now. We're going to amend our charter and say that you have to regulate in this way, which is, I think, what 301 attempts to do. The people have broad powers to enact legislation directly under Article 5 of the Constitution or through their elected representatives. Okay, that's what we have in this government. We have two ways of governing ourselves. Okay, we can allow our elected representatives to govern for us. We give them their powers, or we can take them away and we can do it directly. All right? Colorado is one of about 30 states that has direct democracy in some form or another, and that's what this is. Okay? So, the powers of sovereignty are vested in the people and are exercised in the people, either directly or through your representatives. This is what Colorado Constitution, Article 5, Section 1 says. All right, and I'll read them. So when we set up the legislature, we gave it its power. The legislative power shall be vested in the General Assembly, but the people reserve to themselves the power to propose laws and amendments to the Constitution and to enact or reject the same at the polls, independent of the General Assembly. And I'm going to tell you what independent means. This is what Article 5, Section 1(9) says. This is the local right of initiative. It says, the initiative and referendum powers reserved by the people in Section 5, in Article 5, Section 1, that I just showed you, are hereby further reserved to the registered electors, the voters, of every city, town, and municipality as to all local, special, and municipal legislation of every character in or for their respective municipalities. Now this every character. So what does it mean to legislate independent of the General Assembly? Pretty simple. Not dependent. Okay? Not subject to control, influence, restriction, modification. The legislature cannot tell you what you can do in or for your respective municipalities when you pass an initiative. Okay? Pretty powerful. Now, whoa, you say. Well, that means, could we say nobody from Libya can live in Broomfield? Well, no. Because the Constitution grants rights to individuals, right? To be free from discrimination against their national origin. Those are personal rights, but that's not a preemption matter, okay? That doesn't give the state the power to say to a local government, well, you can't pass legislation. I want you to think about a wristband that says WCTLD. What could the legislature do? No, really, think about it. What could the legislature in Denver do? Okay? Well, they pass stupid stuff all the time, right? But that doesn't mean that the governor can come in and basically say, no, you can't do that, right? He can veto it. Under Article 5, the governor cannot veto an initiative. It's explicitly in Article 5, Section 4, okay? Now, so if you think about, could the legislature in Denver restrict where fracking can be done? Could it set setbacks wherever it decides is best for the health and safety of the people? Yes, clearly they can. You can too, okay? Now, what does it mean, every character? All right? That means no exceptions. There aren't any exceptions for oil and gas legislation. Okay? You have the right to pass legislation of every character. Okay? And the Supreme Court has said they have to interpret this provision as being a reservation of the people. It should not be narrowly construed, and we're not going to read any exceptions into the language of the Constitution. If it's there, it's there. That's what the Constitution means. It says what it means what it says. Well, can't the COGCC just preempt 301? The General Assembly has no power to enact any law that denies a right specifically granted by the Colorado Constitution. It cannot prohibit the exercise of constitutional powers regardless of the state's interests that may be implicated by the exercise of those powers. Okay? Take that in. If it's in the... Now, a statute can override a city government's legislation through the fiction that is Dillon's rule. Okay? That's all it is. All right? because the state created the municipal corporation, gave it its powers, it can take them away. That doesn't apply to the people. The United States Supreme Court has said in 1906, I believe, that Dillon's rule applies to the municipal corporations, but it cannot be used to deny the individual or collective constitutional rights of the people of that municipality. Okay? Now this is, you're not going to hear this anywhere else. I can almost guarantee you. So it's also, your right of initiative is something called a fundamental right. Not all rights are equal. Okay? Some are fundamental rights. They're so important to the founding of the country that the country would not have been in existence without protection of these rights. The rights to liberty, life, liberty, pursuit of happiness. That's just the basics. Okay? Protection of your health and safety. Right? That's the reason for the police power. That's the reason why local governments exist. And the Supreme Court has said it's a right of the first order. That it's first. Okay? Everything else is below it. And it's like the right to vote. It's a fundamental right at the very core of our Republican form of government. So this is what you're doing when you're voting on 301. Okay? You're exercising a fundamental right. And that right can't be taken away without what's called strict scrutiny, meaning it's the highest level of, it's the highest hurdle that a state has to overcome in order to eliminate a right and say that no, we've got to stop that. All right? And the Supreme Court has called strict scrutiny strict in theory, fatal in fact. Okay? The state almost never wins that argument. So preemption is the great deception. Right? Your rights disappear and money appears for the industry. It's true. But as with all magic tricks, a good magician still needs able assistants. The beautiful assistant that distracts your attention, or the loud person in the audience that disrupts and takes your attention off of what's really going on, right? And so the fracking industry has its able assistants. Unfortunately, some of them are in local government. So this is Dillon's rule. It was 1903, older than that. So constitutional rights can't be preempted. Right? If it's in the Constitution, it's explicitly in the Constitution, your right to pass legislation of every character in or for your municipalities can't be preempted. Now, I'll get into why the City of Longmont case and the City of Fort Collins case, why Longmont's ban was preempted. It's all part of the magic show. Okay? Now, the earth has shifted because of the Martinez case. And I guarantee you, the oil and gas industry knows this. As was said before, this was a bunch of teenagers, Tesco Martinez and others, Earth Guardians, youth plaintiffs, brought the case in order to stop oil and gas permitting until the agency could show that it was being done in a manner that would protect the public health, safety in the environment, and the climate, prevent, adverse impacts on the climate. And we submitted almost 50 pages of supporting material, including from some of the leading climate scientists in the world. Okay? Of course, the agency denied the petition. So we took a complaint to the district court. District court denied rejected our complaint, sided with the industry. So we took the case and appealed to the Court of Appeals. The Court of Appeals found that the Oil and Gas Conservation Act, the statute that gives the COGCC its powers and mandates its powers, has been misinterpreted by the agency for quite a long time. The agency said, well, we have to balance oil and gas industry interests, mineral rights owners' interests, and against the public health and safety in the environment. That's how they came up with 500 feet for setbacks, okay? They said, well, we've got these extremists, like all you people, who want, 2,000 feet, and then we've got the oil and gas industry. They want 300 feet. They want this to be the same, or maybe less. And then, so they just said, we'll pick something in the middle. Literally, they just balanced it. And the Court of Appeals said, no, the balancing is not the proper interpretation of the statute. The statute is conditional. It says the agency is to foster the responsible and balanced production of oil and gas development in a manner consistent with the protection of public health, safety, and the environment and wildlife resources. Now, it says it's a conditional statute. If the second part isn't met, the first part isn't going to be done. Okay? If it's not done in a manner that protects public health and safety and the environment, it's not responsible and balanced development. Right? So that only happened because these teenagers had the courage, and my co-counsel from our children's rights in Oregon, they had the courage to basically stand up and say, we're not going to take this anymore. Okay? And courage is contagious. All right? When you show courage, other people show courage. Right? They feel like they can do it. And it's starting to show up in the courts. Okay? Now this is 301. It's a local version of the Martinez ruling. Okay? Now, and I've just pulled out some of the language. Broomfield shall condition all oil and gas development permits to require to only occur in a manner that does not adversely impact the health, safety, and welfare of Broomfield's residents in their schools, parks, etc., etc. Okay? That's simply what the Court of Appeals said must be done under the Oil and Gas Conservation Act. Okay? But we know that the COGCC is not doing it. Okay? If the state won't protect the public, local governments have that power. All right? It's called the police power. Come on. All right? It's been around since the founding of the country. All right? The power to protect the public health and safety and prevent nuisances has always existed in cities. But if the city government won't protect the public, then the people have the right and the power to protect themselves. Right? That's what the initiative, the referendum, the right of recall, these are fundamental rights, okay? Under the Constitution. And that's where we are. All right? Now, we can argue about why the city government is not protecting the people, whether it's because they're intimidated by preemption decisions or they just don't want to get sued because they don't want to pay lawyers to defend, against the case. There's all kinds of reasons, all right? But the bottom line is the public needs to be protected. So somebody's either going to show courage and stand up and fight back, or you all have the power and the right to do it. Now the COGCC says one thing and does another. This is Weld County, okay? And it's from a while back. So I imagine some of those lighter areas have been filled in by now. Okay, this is what preemption looks like. This is what it does to people. This is the house in Firestone. Okay. Now we could have predicted that Firestone would happen. In fact, I did predict it. I mean, I'm not joking. It's an unbelievable, form of negligence. Okay, allowing these pipelines to exist underground, unmarked, unlocated, allowing Anadarko to go back into an abandoned well without testing the flow lines to see if they were closed or not. And then you ended up with this. Okay? Now, you would think, well, that should wake them up. But no. Okay? Attempts to get, just in Thornton, they just passed regulations just to do the simple thing of requiring oil and gas companies to map their own pipelines, their own flow lines, and reveal where they are and that they're compliant, right? That they're not leaking, because massive numbers of these things were leaking, right? No, the industry says no, so they've sued. Okay, this is what they do, right? And they'll sue for preemption. And so people have to understand that for whatever reason, they're going to have to take back their power to protect themselves. The following view of Firestone is what COGCC enforcement looks like. Yeah, they're all there. Crestone, Kerr-McGee, Anadarko, Patina, PDC, and the green lines, I mean, this isn't even the pipelines. This isn't the flow lines, okay? Those haven't been all mapped. So, Broomfield, this is coming to you. Reckless disregard for public health and safety. 2 weeks after Firestone, the agency approved 500 new permits. Okay? They are acting as if the Martinez opinion doesn't exist, that it doesn't apply to them, okay? Until the Supreme Court rules on the appeal, whether to take the appeal or not. This is a published decision, okay? It's precedent, and they should be following it, right? But they're not. Common way people give up their powers by thinking they don't have it in the first place, okay? I'm hoping that you will start to learn more about what your power really is, right? Because you have it. And you've had it for quite a long time, but we've, through decade after decade of messaging and really propaganda, okay? You've been told you're powerless. You can't do this because the state controls that, all right? The preemption, I call it the preemption hustle, okay? Because what happens is, so in the city of Longmont, Fort Collins, Lafayette, 2012, 2013, and Broomfield all passed initiatives, all right, in order to ban or put a moratorium on fracking, and those were struck down by the Colorado Supreme Court. So what happened? How did they do that? All right. Well, COGA, Oil and Gas Association, it's kind of snuck in. They came in and sued the municipal corporations. They sued the cities, even though this wasn't city government. This wasn't the city councils passing regulations. In fact, the people had to go over their heads, okay, pass these initiatives because the cities weren't acting. So what did the courts do? Okay? Well, they limited it to, the review was limited to the powers of the local government under Article 20 of the Constitution, which is the Home Rule Amendment, which sets out the powers of home rule. Okay? That's the powers of the city council to pass laws in their city. And in their city, city council is supposed to have plenary authority. Okay? State doesn't get to tell a city what it can do in their city. All right? But the trick is, they've created this sort of analysis where if it's not purely a law that impacts people only within the city, if it's what they call a mixed state and local interest, Dillon's rule kicks in. See, Article 20 is what's called an abrogation, a limited abrogation of Dillon's rule. It says in the city limits, okay, city council can do what it wants, all right? But as soon as they can find some way that it's connected to a state interest, then Dillon's rule kicks in, preemption applies, case solved, right? But in every one of those decisions, and every one of the decisions underlying it, there is not one sentence in any of those court opinions, not one sentence analyzing the right of initiative under Article 5, your right of initiative, even though all of them were initiatives passed by the people, okay? So they narrowly framed the issues. They sought to keep anybody from intervening that might raise these issues, and then they had it all channeled, okay? So that the only thing that applies is preemption according to Dillon's rule, which does not apply to you. Okay? How does this apply to what's going on in Broomfield right now? Right. Well, we've been here before. 2013, Broomfield, the citizens passed narrowly, but they passed it, despite overwhelming money disadvantages. Okay? And honestly, statements made from the council and statements made from the city attorney that were designed to influence that election. Okay? But they passed it, despite all that. But what happened just before that election was the city council was in a rush with Sovereign Oil to push through an MOU, okay? To get it on the books before that election, despite, activists were complaining, let us vote, wait on this, let us vote. No, no, no. They had to do this because of something called vested rights, okay? Which became clear after the vote. And after the vote and measure passed, Sovereign Oil filed suit against the city. Against the city, okay? To say, no, we've got these contract rights. They're vested rights. They can't be undone by laws passed after you agreed, you, the city, agreed to give us this MOU. You can't do that. And the city, of course, really fought hard. They just really tried hard to fight against that lawsuit, but unfortunately they lost. And then they didn't appeal. Okay? Despite people saying, please appeal this decision. Right? No, they deaf ears. Okay? And that's all designed because that's why you are in the situation you are in. Okay? Sovereign Oil eventually sold their rights to extraction. That's the only way that extraction even has any rights right now. Now, extraction has said, well, these old rights, all the well locations and all of that, that's no good for us. So we need to negotiate a new MOU. What did they have to do first? They had to get rid of that initiative. Okay? They had to get rid of that initiative. So what did they do in 2016? After the Supreme Court came down with the Longmont decision, your city council, really, and I have not found any public vote, and I've looked, right? No public vote. They just asked the city attorney to walk across the street to the court and agree with COGA to dismiss their lawsuit, invalidating the initiative. Your ballot initiative, your charter amendment was then just denied, rejected by the court. Okay? Didn't give you notice. They didn't give you a public hearing, public meeting, none of that. All right? Once they had that done, then they could start negotiating with extraction. Okay? And as soon as, it was like within a month, they were rushing to start negotiating. Now you guys, activist groups and just ordinary people have done a great job of slowing down this train. Okay? To say, wait a minute, what's the rush here? We need to protect the public health and safety. Okay? And so your task force and all the things that you've done to try to put some brakes on this process have been effective. But watch what's going on and watch, I'm going to predict it. Okay? Extraction in the city council, majority on the city council, not everybody on the council. Okay? But they're going to do whatever it takes to vote on this thing before this election on 301. Okay? because they want to create vested rights in extraction for 5 more years with a renewal right. Okay? That's what's going on. Now, but there's one thing you need to understand. Vested rights, let's say I'm a developer and I get a permit to build, right? I have a vested right in that if I've spent money on it, I've already invested some money in developing, and then the city comes back later and says, no, you can't do this and that, right? Well, I say, I've got a vested right. You agreed I could do it. You gave me a permit. Well, cities always have the ability to come in later and say, no, you can't do that because it's a nuisance, or it's going to violate your public health and safety, right? Cities always have to have the ability to legislate and to pass laws that don't grandfather in just, the most horrible projects, okay? Just because they have a vested contract, right? So you always have the ability to pass a law, 301 is one of them, that says, no, this MOU doesn't protect the public health and safety and the environment. So your vested rights, don't apply. Now, but that's not just going to magically happen, right? Somebody's going to have to basically bring a lawsuit. I'm trying to be a predictor here, right, of what's going to happen. So, another thing you're going to need to do is pull back the curtain on the wizard. Okay? There's all this stuff, all this activity going on behind the scenes, right? No, you can't have access to that. That's privileged. That's negotiations, right? This is your information. It's public information. It's a public project, okay? That's the reason why the Open Records Act and the Open Meetings Law exists, okay? These are pillars. Open records, open meetings, these are part of democracy, and they're really essential for democracy. You've got to have access to the information about what your government is doing. Now, I'm not being personal here. I'm not attacking anyone. We need sunshine, all right? It's your information. It's being paid for with your dollars, okay? Insist on knowing what's going on, all right? And then finally, whenever possible, focus back on where you want to be, all right? What's the reason why we're fighting for all this? We want renewable energy, right? We want a restored environment. And we want resilient communities where it's safe, it's healthy, where kids aren't getting nosebleeds 3 times a week, okay? We're not being kept up all night by noise. It's, like airplane flights. We want the power to say what goes on in our community and what doesn't, and where it needs to be in order to protect the public. Okay? That's the power that is basic to communities. Okay? That's what's necessary for them to be resilient against climate change, against the end of the fossil fuels. Okay? And so I hope you'll keep that, find space for that vision, right? And then seize the initiative, take back your power. Learn about the constitutional rights that you have. Learn about just your power to organize, your power to, and you're learning a lot now. Because when, there's a old saying, a hanging within a fortnight does wonders to concentrate the mind. And you're facing your hanging within a fortnight. Okay? And you're getting organized. You're getting concentrated. You're figuring things out. You're becoming experts. Okay? That's a good thing. So, that's it.